In another case of Samuel Kamau Macharia and another versus Kenya Commercial Bank, the Supreme Court of Kenya held that a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court of law can only exercise jurisdiction as conferred by the Constitution or other written law. It cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. And where the Constitution exhaustively provides for the jurisdiction of a court of law, the court must operate within the constitutional limits. It cannot expand its jurisdiction through judicial craft or innovation, nor can Parliament confer jurisdiction upon a court of law beyond the scope defined by the Constitution. Where the Constitution confers power upon Parliament to set the jurisdiction of a court of law or tribunal, the legislature would be within its authority to prescribe the jurisdiction of such a court or tribunal by statute law, end of quote. In the petition hearing, the petitioners who state that they form the descendants of the Meru tribe accused the respondents for forcible detention and or unlawful occupation of the suit properties since 1929. Among the relief sought by the petitioners against the respondents are an order of execution, compensation, and nullification of the titles in respect to the suit properties now in the names of the respondents and have the same vested to the petitioners. My reading of the petition is clear that the petitioners have brought the petition on the claim of historical injustice, whereas the respondents want the court to defer jurisdiction to the National Land Commission in accordance with the constitutional doctrine of avoidance. The petitioners are of the view that this court should determine the matter. The respondents pointed out that the petitioners have petitioned the National Land Commission in relation to their historical claims to the suit properties. In one case of a chief land registrar and four others versus Nathan Tirop, Koech, and four others, which was relied on by the respondents, the Court of Appeal stated, and I quote, "The National Land Commission is established under Article 67(1) of the Constitution. Its mandate is outlined in Article 67(2). One of its mandates, pursuant to Article 6(2)(e), is to initiate investigation on its own motion or on a complaint into present or historical land injustices and recommend appropriate redress. On the question whether a court should await investigation and recommendation by the National Land Commission before it can entertain a claim founded on historical injustice, it is our considered view that a court has jurisdiction to hear and determine any claim relating to historical injustice, whether or not the National Land Commission insists of the matter. Our conviction stems from our reading of Article 67(2)(e) of the Constitution. The article provides that the National Land Commission can investigate present or historical land injustices. We lay emphasis on the word present. If the National Land Commission had an initial and exclusive mandate, it would mean that all present cases on land injustices can only be handled by the National Land Commission and not courts of law. This would prima facie render the Environment and Land Court redundant. We do not think this was intended to be so. Our view is fortified by Section 15(3)(b) of the National Land Commission Act, which permits the Environment and Land Court to deal with historical injustice claims capable of being addressed through the ordinary court system. Further, there is nothing in the 2010 Constitution or in the National Land Commission Act hosting the jurisdiction of the High Court or barring a person from presenting a petition before a court in relation to a claim founded on historical injustice. End of quote. In another case of SEPAC Limited and Father Henry Wambega, the Court of Appeal also considered the question whether it is within the mandate or jurisdiction of the Environment and Land Court to deal with historical land injustice claims, and held that the above passage, which I have, in the case of Chief Land Registrar and 4 others, which I have just quoted, accurately represents the state of the law on the matter and provides a complete answer to the appellant's contention on jurisdiction. The Court of Appeal also on another issue, whether the petitioner's first port of call before approaching the Environment and Land Court should have been the National Land Commission, on which the specific function of carrying out investigations into historical land injustices is vested, and held as follows. Where there is a clear procedure for the redress of any particular grievance prescribed by the Constitution or an Act of Parliament, that procedure should be followed, provided that the remedy thereunder is effectual. It went on to state that based on the material placed before the court, it would appear that the petitioners did indeed refer the claim to the National Land Commission, the 12th respondent in this appeal. There is, for instance, a letter dated 21st September 2017, in which the second respondent states that it is mandated to resolve disputes like the one pertaining to this parcel, that the Commission is keen to settle this dispute, and that the National Land Commission Kilifi office is working on this issue. The record of appeal is, however, silent on the outcome of the intervention by the National Land Commission, which, though briefed to this appeal, did not participate in the hearing of the appeal. End of quote. The Court of Appeal in the above case held that the Environment and Land Court was right in holding that it has jurisdiction over the matter. It can be noted from the above decision of the Court of Appeal, which is binding on me, that inasmuch as the National Land Commission has a mandate to look into historical injustices, an individual can still commence a constitutional petition on a foundation of historical land injustice. It is therefore my finding that this court has jurisdiction over the petition hearing, and I decline to defer jurisdiction to the National Land Commission. And just like in the above cited case, I have produced the material placed before the court. At page 100 of the petition, there is a letter dated 7th of September 2021 from the petitioners, and specifically the first petitioner, National Land Commission. In the letter, the petitioners met an obligation for the conversion of land reference numbers 72262 and 2811 R, also known as Kisima Farm, located in Meru County, from public land into community land in favor of the members of Meru Cultural Center. The said parcels are part of the suit properties herein. The record, however, is silent on whether the National Land Commission acted as required by the petitioners, and if so, the outcome is not disclosed. That notwithstanding, and having found that this court has jurisdiction to determine the matter, I will proceed to consider the issue, which is whether the petition has met the constitutional threshold required in such petitions. It is a well-established principle in constitutional litigation that a party alleging violation of his or her constitutional rights must plead with a reasonable degree of precision the manner in which there has been such alleged violation. This proposition was enunciated by the Court of Appeal in the case that I referred to earlier of Anarita Karimi Njeru versus the Republic, where the court stated, and I quote, constitutional violations must be treated with a reasonable degree of precision. The Court of Appeal reaffirmed the above principle in the case of Mumo Matemu and Trusted Society of Human Rights Alliance and 5 others. I have perused the petition herein. Save for citing the constitutional provisions in the title of the petition, the petitioners have not stated how the respondents have violated Articles 1, 2, 3.1, 10, 9 to 23.1, 25.1, 27, 35, 40, 43, 47, 48, 50, 60, 69 to 63 to 69, and 156 to 6 of the Constitution. I am in agreement with the respondent's submission that the petition is based on generalized allegations that the respondents participated in the forceful displacement of the petitioners from their lands. The petitioners have not provided particulars of the allegations of organized, cruel, and forcible detainer, and neither have they disclosed the manner in which the Constitution has been violated in this regard. In addition, there are no particulars presented of the properties mentioned in the petition and to whom they belong to, which of the petitioners for others were supposedly dispossessed, the suit properties through organized, cruel, and forcible detainer, by whom, when, and in what manner. Moreover, the petitioners have not specified how each of the respondents has violated any of the petitioners' constitutional rights. As rightly submitted by the respondents, the whole object of pleadings is to bring clarity to an issue. However, looking at the petition as drafted, it is difficult to decipher the issue the petitioners want the court to determine. In this case, the petitioners have enjoined 25 respondents in the petition. That means the petitioners must have a specific complaint against each of the respondents. In addition, the complaints must transcend ordinary claims on failure to comply with certain statutes to constitutional issues. Whereas the petitioners may have valid complaints against the respondents, such cannot be prosecuted in an omnibus style. It is imperative that pleadings are drafted with certain degree of clarity and specificity as to accord a respondent a fair opportunity to know what the complaint is all about and to possibly prefer a response thereto. Given the nature of the petition and the gravity of the issues raised, there remains the need that the pleading be crafted in such a manner as to demonstrate how each respondent violated which of the petitioner's constitutional rights. It is therefore my finding that the petition does not meet the threshold for constitutional petitions established in the Narita case, which I have referred to, and must fail. The petitioners, in my view, will not suffer any prejudice as they can still pursue their application already lodged with the National Land Commission, the 21st respondent hearing. In the result, I find that the objection raised is merited to the extent that the petitioners have failed to plead with precision the constitutional violations, the particulars of their complaints against the respondents, and the manner in which the Constitution has been violated in relation to their complaints, and therefore has not met the threshold established in the case that I have referred to. Consequently, the petition is hereby struck out with costs to the 1st, 2nd, 3rd, 8th, 9th, 10, 11, 12, 14, 13, 14, 15, and 16 respondents. Those are the orders of the court.
May Your Lordship apply for a copy of the
Most obliged, Your Lordship.
and I wish to apply for stay of execution of the ruling.
What are you saying? I have not given any positive order that warrants stay. I've only dismissed the petition. There is nothing that I've ordered that somebody can execute. So what's the
In the
amount?
event of any misdemeanor.
If you need to be specific. What is your apprehension? What have I made that can be subject to execution?
In case of any abuse of court process.
No, if in case of such, you can always, the court is always available. You can approach the court for remedy.
May I be on record? May we be on record for having sought for that release?
No, the leave I will grant you.
Most of them.
Yes. You said that you are number 19.
We also would like to have a copy of the site proceedings. We are ready to pay whatever charges that could be raised. In fact, all the proceedings until now to allow us to take the necessary remedial action.
So, leave to appeal is granted as prayed.
No, we have not applied for it.
So what did you have?
We applied for copy of the ruling.
It's only copy of the ruling.
Yes, we are not appealing yet.
So certified copies of the proceedings and ruling to be supplied to the petitioners as prayed, subject to payment of the requisite court fees.
Most of them.
So can I say to all the parties then? To the,
Which to all parties. Sorry for missing the record.
so and I've added that to be supplied to the petitioners and any other party as prayed, subject to payment of the requisite court fees. Yes, next. Come più.
Thank you.